Now we're going to transition over to marijuana and employment law. Joining us today is Jordan Schwartz. Jordan is a partner in the Conn, Maciel, Carey law firm in the Washington, D.C. office. Jordan represents employers in litigation at both federal and state levels. Even though he's in the D.C. office, I want everybody to know that Jordan has a national practice, and he devotes a lot of his time and energy to Title III of the ADA. As a matter of fact, I don't think there's anybody that devotes more time to Title III of the ADA and all the litigation that goes on out there and preventing that litigation than Jordan does. But he also has a broad-based practice in all aspects of labor and employment. Ladies and gentlemen, please welcome Jordan Schwartz.
Thank you very much, Stephen. I will try to be looking at the screen, but I always have information everywhere that I'm looking at, so I apologize if I'm looking away sometimes. Thanks for having me. Yeah, typically for hospitality law, I speak on the ADA issue and how to accommodate guests in hotels and restaurants. But here, I decided to go a different path and talk about some of the other employment type issues I counsel on and litigate on. And one of them is drug testing and marijuana issues. Of course, it wouldn't be a presentation that I give if I don't mention the ADA. So the ADA will come up in this presentation also, although that is Title I of the ADA, which is very different than Title III of the ADA. But I'll explain that as we go. A quick agenda here is I'm going to give a little bit of the background on the laws relating to drug testing. And specifically marijuana. And then, as I mentioned, we'll talk about the ADA issues because those are really the most prevalent issues with drug testing laws. And then, I'll give a few examples of some state laws and importantly, where it all ties together is the employment law implications, for you running your restaurant or hotel or your business. It's the implications of how do we deal with these laws, and really the questions we're going to want to answer are as an employer, can we legally require employees to take drug tests? If so, can we require job? If so, how do we do that without discriminating? What about applicants? Do we treat applicants different than current employees? And again, in both contexts, how do we make sure we don't run afoul of the law? Because as I'll explain, if we go to the next slide, there's no comprehensive federal law that regulates drug testing in the private sector. There's tangential laws. The Supreme Court has ruled that drug testing is lawful and it can be necessary. It's possible it can infringe on someone's privacy, and I'll get to that in a minute. But for the most part, marijuana is legal. It's illegal under federal law. There's no comprehensive federal law that regulates drug testing, and there's a patchwork of laws throughout all of the states. Almost every state has a different law relating to drug testing. So this really creates uncertainty for employers when trying to implement and apply work policies, especially if you're just trying to get a handle of the law in your own state, but also if you're trying to get a handle of the law and you operate in different states. So in order to consider, let's say, the ADA, federal discrimination laws, and various state laws that you need to consider, it's just difficult for employers to really have a great understanding of what to do. So I will do my best to give you a general understanding. At the end of the presentation, if there's not time for questions, hopefully my contact information will be listed, so you can always contact me me with specific state law issues, because sometimes where the rubber meets the road is the specific state law. But I'll get to that as we go. Moving on to the next slide. Federal law. There is something called the Drug-Free Workplace Act. That is only if you are that only applies if you're a federal contractor. I am not sure how many of you on the call today are federal contractors. I'm assuming not too many, but it's possible there might be a few. And just the very, very broad highlights here are that the Drug-Free Workplace Act does not require drug testing per se, but it does require you to have a very specific drug-free policy according to a certain program. I am not going to get into the details now, but if that's something, if you're a federal contractor, hopefully you are aware of that. If not, that's something you need to be aware of. There's also testing and or drug-free policy and program are also required for various public safety and security positions, for the Department of Transportation and the Department of Defense, which I don't think anyone on this call is a member of. But what most of you just need to remember here, and what is that marijuana is a Schedule I drug under the Federal Controlled Substances Act. And where that comes into play is that, various states, that say you can potentially allow drug testing or certain aspects of drug testing as long as it's not violative of federal law. And then you have marijuana here, which is violative of federal law. And it's that state and federal law that kind of, they're bumping into each other. And that's where a lot of these difficulties arise. And it's really frustrating where some cases have in various states, some judges say, well, the state law says it's permissible, so we'll allow an employee to, potentially seek an accommodation for marijuana use, while that same jurisdiction can have another case that says it's prohibited by federal law. So, an employer is fine to make whatever decision it wants regarding that employee. And again, as an employer, that makes it difficult for you to take definitive actions. But moving on to the next slide.
Jordan, real quick, before you jump in there, I just have a quick question for the hotel folks that are on. All the hotels probably have federal employees stay with them. It's a federal rate that's published, right, that they can charge. In your opinion, and you may not know the answer to this off the top of your head, I understand, but I'm throwing it out there because I'm sure I think other people might be wondering. Does doing business with the federal government, having them stay at your hotel, does that in and of itself make you a federal contractor?
You're right. I don't necessarily know the answer with that. I think there are certain, to be a federal contractor, I think there are certain monetary amounts that you need to do business. Let's say you need to do, I don't know, $100,000 worth of business with the federal government to be considered a federal contractor. I'm making that up, but I think there is some threshold that you're either over or under. And I think most hotels, probably know whether or not they are considered a federal contractor. I don't think just doing a small amount of business with having federal employees stay at the property would translate into the employer necessarily being considered a federal contractor.
Thank you, sir.
You're welcome. I hope that at least somewhat answered your question. Again, I don't want to spend much time on this, but this is just, for the federal folks, the marijuana use would be prohibited, and it can be tested both in in pre-employment, certainly post-accident, if there's any sort of accident, if there's reasonable suspicion, if you decide as an organization to do random testing, and certainly as a return to duty and follow-up. And there's specific regulations on how the drug testing is conducted, and things of that nature. But I don't want to spend too much time on that just because I don't think that's going to be the majority of the people on this call. So to go to the next slide here, we are now going to move on to state law. And I only have 20 or so minutes here, so I'm not going to talk obviously about every state. I'm going to give a few examples as we go, including in DC where I am, where we just passed a new extremely permissive law for employees who use marijuana. But for the most part, I'm just going to kind of give a few rules of thumb here. Employers generally, as the law has developed and still now, have the right to test for drugs. I give the caveat of I have to, I'm a lawyer, unless there is a restriction in state law, but most states allow you as an employer to test for drugs. It's possible it might be limited to reasonable suspicion or probable cause situations. You see someone acting funny, you say, uh-oh, they're acting in a way that is very different than they typically act. We are going to do some sort of drug test. A lot of states impose restrictions on public sector employees, but are basically hands off for private companies and do not impose the same restrictions. Almost all states mandate specific methods for actually handling the specimens and how to drug test. And this is where you as an organization can get into difficulty if you don't follow those specific instructions. And it's also interesting how some states have limits on pre-employment marijuana testing. DC, for example, says you cannot test an applicant until they have a conditional offer of employment. I don't fully understand the rationale for that, because they're just kind of pushing the can down the road. Because if you have a rule, if your company has a zero tolerance policy, and starting very soon in DC, you won't be able to have that. But let's say you have a policy that says we don't employ someone who tests positive for marijuana. You then have to go through the whole rigmarole of giving them a conditional offer. Then you can test them, and then you can reject them. I'm not sure why you couldn't have just done that earlier, but that's the DC law. But other states, and what you should do, certainly in your organization, if you have any safety sensitive positions, you should certainly be testing for safety sensitive positions. Random drug testing, that's really a company by company decision whether or not you want that. And as I think I said earlier, some states have absolutely no restrictions whatsoever. And I'll get into a slide in a minute. That doesn't mean you can do anything. It means there's no state law restrictions, but you still don't want to violate the law in other ways. And again, I will get to that in the next slide or two. And yeah, here we go. There are, regardless of what your state says, there are just general guidelines of things you do not want to do as a best practice for as an employer who's considering drug testing. One, discrimination. We'll get to disability discrimination in a minute, because that I'm leaving as a subsection and its own topic. But hopefully no one on this call does this, but you don't want to single out a certain group of employees for drug testing, whether it's by race, gender, any protected characteristic. If you do that, you certainly would face a claim for discrimination. You can single out a specific job, If you want to test all your all your truck drivers, because you want to make sure they're not impaired while driving, that is lawful. Yeah, it's possible if you only have male truck drivers, someone could assert, hey, that's a discrimination claim. But as long as you're doing it consistently and you have a rationale for a specific position, I'm not too concerned by some sort of disparate impact claim there. You want to be careful, but by job category is okay. As I mentioned, violation of laws and procedures. Although a state may have the legal right to engage in drug testing, you still need to follow the state's requirement. For example, Maryland, where I live, an employee can bring a legal challenge against an employer who did not have a legitimate business reason to test, or did not provide documents that were required to be provided following the drug test. As I mentioned, there are also just specific handling of specimen procedures and how long the process takes, how long you get it to the company to test. Usually you kind of outsource this and you have a company doing it for you, but you need to make sure they are following the proper procedures in your state. Invasion of privacy. Even if you're allowed to test for drugs, but the way you do it, you require an employee to disrobe prior to giving you a urine sample or something of that effect. Just make sure you're not doing it in a way that can be an invasion of privacy. And defamation. An employee could potentially have a valid claim for defamation if you as the employer publicize an employee's positive test result, especially if for whatever reason you have reason to know that it might not be an accurate test result. So just be careful about any potential defamation claims. So you don't want to reveal the positive test beyond those in the organization that have a right to know. Moving on to the next slide here. As I mentioned, we really need to be careful of the ADA. So drug testing is allowed under the ADA because the ADA does not consider drug abuse to be a disability. It's interesting. If you have recently recovered from drug, alcohol, or addiction, that might be considered a disability under the ADA, but current usage of drugs is not considered a drug abuse, is not considered protected under the ADA. It really is complicated. And it can be very tricky for employers. But disability discrimination is the most significant legal risk when deciding whether or not to engage in drug testing, because as we know, an employee who is might be taking medical marijuana, and that may be for someone's disability. So you need to make sure that you are implementing any sort of drug testing policy consistently. As I mentioned earlier, either all the employees, none of the employees, maybe only a certain job category, maybe a safety sensitive position, but not only people who are sick or anything of that nature. If a drug test comes back positive and it was as a result of medication that was legally prescribed for a disability, you need to, think long and hard about whether you want to terminate someone for that positive drug test. That goes into the analysis that I'll talk about in a few minutes about whether you want kind of a hardcore zero tolerance policy or whether you want to have exceptions for someone who is legally taking medications such as medical marijuana. Another issue, we'll go to the next slide here. Another issue is dealing with the ADA reasonable accommodation process. Andrea, slightly mentioned that there's an interactive process in the ADA, and when someone requests an accommodation based on an employee's request, you need to, go back and forth and decide what accommodation you can grant. Someone who is, taking medical marijuana may ask for an accommodation, or something else related to their disability, another disability, and you require a drug test. I've seen a few cases where I don't fully understand the employer's rationale, but maybe they were trying to employ this policy consistently. And this gets into one of the difficulties that Andrea mentioned, is that we tell you to employ these policies consistently, but you also need to potentially address an individualize an accommodation, and then actually treat someone differently. So we do speak kind of out of both sides of our mouth. But what happened in a few of these cases I saw were that an employer required an incoming employee to take a urinalysis as a drug test. The employee said, "No, I can't do that. I have renal cancer. It's not possible." The employee said, "How about I give you a hair follicle? I do a hair follicle test." And the employer said, "Nope, that's not good enough. We're going to revoke your job offer." And the employer was found to be liable. So I would argue that, although I'm defending the employer should have considered other tests that may have led to the same outcome. So just be aware of those types of issues that come up in the ADA context. Moving along, let's go to the next slide. I'm certainly not going to read off all the states here, but almost 40 states here allow for marijuana in some context, and half of those allow for recreational marijuana. And then about, a dozen or so have anti-discrimination provisions in their medical marijuana laws, and DC should also be on this list now. And what that means is that you need to be really careful if someone asks for an accommodation for medical marijuana use, if you are in any of these states. And that gets me to the next question here on the next slide is it lawful to terminate an employee who tests positive for marijuana? And there's a few things to consider here. One is, where did this occur? Did the marijuana use occur on your property? Did it occur during working hours? Did it occur for this employee who is in a safety sensitive position? Were they impaired when you saw them? Or is this just a positive test that came back that was not impacted at all in their job performance? And that is one of the key answers here, or key issues to determining this answer. And let's go to the next slide here while we're still talking about really the same issue. Is if you're in one of those states that was just in that two slides ago, you need to determine and the employee will certainly tell you, was the positive test because it was pursuant to a valid medical prescription? And again, was it on off hours or was it for off hours and off-site recreational use? In almost all states still, DC now being one of the notable exceptions here, if marijuana is legal recreationally, and if it is off hours and off-site, you can still terminate that employee for their marijuana use. I know that might seem a little counterintuitive because it's legal, but it is legal, from a criminal standpoint. Again, I am generalizing for most states. This is the great majority. It is not all of them, but it is legal like alcohol is legal. You cannot get arrested in those 22 states for off hours and off-site recreational use. That does not give an employee a guaranteed right to employment. However, if you as the employer have decided that you want a policy that prohibits employees from using marijuana, you most likely will be able to terminate them for off hours and off-site recreational use based on a positive drug test that you received. Again, it gets trickier if then, based on that drug test, you get information that it was pursuant to a valid prescription. It is still lawful in probably in more than half the states to terminate someone, even if it is pursuant to a valid prescription. But it is a little more dicey. There are more states, including the ones that were listed 2 slides ago, that do not permit that. And even if it is permitted in your state, you could become one of those test cases where you become the employer who actually loses the test case, and you are ruled to have violated the ADA by not accommodating an individual who had a valid prescription. That is, again, where these examples meet the law that I gave you earlier under the ADA. If you go to the next slide, I just had a sample slide here for Michigan, which is a state I actually presented on this topic a few weeks ago, but it's a good example of a state that really it has a law, but the laws don't really say much. So you can do whatever you want as an employer. They do not, number one, the laws in Michigan do not restrict employers' rights to test employees and or job candidates for marijuana. 2, zero tolerance policies are enforceable. 3, employers are free to discipline any employee or refuse to hire a candidate for employment who has tested positive for marijuana, regardless of whether they have a valid prescription. And 4, despite the law, they are not required to make any accommodations for employees using medical marijuana in the workplace. So if you follow the law in Michigan to a T, you can do whatever you want. Again, for number 4 there, I'd be a little cautious because at some point the law could change. And I'd argue, at some point in the next 5-10 years, that law will change. I can't guarantee that, but that would be my assumption. So going on to the next slide here, right before I wrap up, we're going to talk here about zero tolerance policies. What you need to decide as an organization is whether or not you want a zero tolerance policy, or if you already have one, whether or not you want to change that. There's no indication from my involvement on this topic that employers are relaxing standards for jobs that are safety critical. There is, however, a lot of evidence that employers are relaxing standards for positions that entail relatively low risk of injury or error, such as many of the jobs at restaurants, hotels, and others in the hospitality industry. And of course, where the rubber meets the road here, why are zero tolerance policies being relaxed? For the most part, employee retention and employee recruitment. Everyone knows how difficult it is to find good employees these days, and it's much more difficult to find good employees if you are taking a zero tolerance drug testing policy line here. I don't have to, you have these bullet points in front of you. I don't need to read every one, but you should really look at them, consider your risk tolerance, consider your workforce, consider your culture, and really figure out whether or not this is something that you think makes the most sense in your in your industry and in your specific company? It's possible the answer is yes, but it's also possible the answer is no. And this is really the slide I wanted to kind of leave up here and have you focus on is, I try to help my clients succeed in their business. And I think I gave you a lot of law, but this is the policy that's kind of thinking about the business aspect of the law and how you want to address this ever-changing law going forward. And on that note, I think I'm exactly at my time, Stephen.
Yes, you are, Jordan. That was excellent. Wow. I want to emphasize that last bullet you had down there, which was the policy should never excuse the employee using marijuana, right, or being under the influence while working. Is that a fair way to read that? Yeah.
Oh, yes, that is correct. I said I wasn't going to go through each of them, but I probably should have read that last one because that's why, or put it in bold. That's why I have it right there. So you don't miss that somewhere in the middle. And I tried to stress that a few times in the talk. Everything I said about what you can allow and what you can't allow, there is no law and there won't be a law, I don't see any time in the future, that will require you to excuse an employee who is impaired while working.
Yeah, very good clarification. Thanks for that, Jordan. And Jordan mentioned, here's his contact information. Take a screenshot or a photograph. Like I said, he has a national practice. He stays current on all this stuff in all the states. So whether it's Title I, Title III, drug testing, and other challenges, he's very insightful around these things. Jordan, thank you very much for joining us once again.
My pleasure. Thank you.
See you soon, I hope.
Yes.